Works. Yeah,
Yep.
okay.
Good afternoon. This meeting is being live streamed. And I just wanted to tell you I am wearing my prescription sunglasses because they help me see. They're not just for glam. Okay, welcome to RBKC's Licensing Subcommittee and thank you for attending. I'm Councillor Janet Evans and I will be chairing this meeting. The committee for this hearing comprises Councillor Marie-Therese Rossi and Councillor Linda Wade and me. We are joined by Sharon Dyball from the Council's licensing team, our legal officer, Lindsay Lemasurier. Also with us are our committee officers, Jerome Treherm and Nima Mahudin. Before we start the hearing of this case, just a few ground rules. Please keep your microphones on mute until you are invited to speak, and turn off your phone. We can only have 2 mics on at any time because of the bandwidth. The case before us today is to vary a license for Stumble Inn, 1 Russell Gardens, W14. Now, I can confirm I have no declaration of interest to make regarding this case. Do the other members have any declarations to make? Councillor Rossi?
No, I have no declaration to make.
Councillor Wade?
No declarations.
Thank you, colleagues. For clarity, I will outline the procedure of the meeting, which has already been circulated with the papers. First, the licensing officer, Ms. Dyball, will give a brief outline of the application. Please, could you confirm your attendance? There you are. Thank you. Then I will ask applicant's legal advisor, Mr. John Payne, to present his submission. He will have up to 10 minutes to do so, and he is joined by his client, Mr. Nathan Kumar, who may be able to assist members should they have any questions. Could you all confirm your attendance, please? Thank you.
Yes, indeed.
Then questions may be asked by members of the committee, the legal officer, and environmental health of the applicant. Next, the environmental health, Mr. Philip Richardson, will present his submission. He will have up to a maximum of 10 minutes to do so. Please, could you confirm your attendance?
I'm here, Chair.
Thank you. Then questions may be asked by the members of the committee, the legal officer, and the applicant of environmental health. Then questions may be asked by members of the committee, the legal officer, and the applicant of environmental health. After this, we will ask our legal officer, Ms. Lemasurier, to deal with any questions she may have, and then she will lead on the draft condition session. The list of potential conditions has been circulated to all of the parties prior to the hearing. Please, could you confirm your attendance?
Present, Chair.
Thank you. Finally, we will turn to the governance team to see if any issues have been raised that we need to consider. There will be no summing up, and the meeting will end. I would like to remind everyone that the committee has read the papers, which comprise the main pack, and the additional submissions that have been circulated to the parties. So there's no need to repeat their content, please, but do draw our attention to certain points and pages. Ms. Dyball, please can you outline the case for us and advise if there has been any additional documentation received?
Thank you, Chair. Good afternoon. This application seeks to vary the premises licence for the Stumble Inn 1 Russell Gardens to add the sale of alcohol for consumption off the premises between 9 a.m. and midnight, and to vary condition 15 of the licence. The premises are currently licensed for the sale of alcohol for consumption on the premises only during the same hours of 9 a.m. until midnight, and late night refreshment indoors from 11 p.m. until midnight. I would just like to point out that the opening hours shown on the current licence at page 12 are incorrect, and they should read 0900 to 0030 Monday to Sunday. The application received one objection from Matt McElroy on behalf of the Council's Noise and Nuisance team, who's represented by Mr Richardson today, on the grounds of the prevention of public nuisance. In his representation, which can be found on page 31 of the report, Mr McElroy proposed 2 additional conditions. However, following further complaints regarding customers drinking outside, a summary of which is included in the complaint summary at Appendix D, Mr McElroy requested an additional condition which would effectively restrict off-sales either to being in sealed containers to take away from the premises or to patrons seated in a designated seating area. A copy of Mr McElroy's email and the applicant's proposed alternative condition has been circulated to all parties. In the last few weeks, there has been some discussion and unfortunately disagreement between the applicant's representatives and ourselves regarding the outside area which customers have been using to consume alcohol and other drinks. Our position is that the current licence only allows the sale of alcohol for consumption on the premises. That consumption can only take place within the confines of the area identified on the plan attached to the licence on page 20 of the report. As you can see from the plan, the plan only shows the building and no outside areas are identified.
Can we have that put up, please? I think it would help to clarify matters.
Is this the plan that's in Appendix H?
It's in Appendix A.
A?
Yeah. Yeah, I think they've got, that's the one, yes. The applicant's representatives have taken a different view and have submitted that as the outside area forms part of the licensee's lease, it is part of the premises that can be used for the consumption of alcohol. We maintain our position that regardless of the extent of the lease, for the purposes of the licence, the premises can only mean that area which is identified on the premises licence plan. Our position is that the consumption of alcohol in any outside area is only permitted if either the outside area is identified on the licensing plan as forming part of the premises for on-sales of alcohol, or if the licence permits off-sales of alcohol. I don't have anything further to add at this stage, but I'm happy to answer any questions. Thank you.
Should we proceed with the applicant's case? Yes. Yeah. Okay. Mr. Payne, please can you advise if there have been any amendments?
Chair, no, there have been no amendments. I'm grateful for the legal officer's suggested conditions, with which there is primarily no objection. I say primarily, there is one small point, and that relates to the question of a tables and chairs licence, because the part of the premises that's considered to be used for drinking outside, let me try that again. The area outside used for drinking is part of the premises and does not need in itself, therefore, a tables and chairs licence. So it would be an impossible condition to comply with in version part 30, where it says any external seating areas authorised by a necessary pavement licence. Well, a licence would not be needed for the extent of the premises. And the extent of the premises, you have, I don't know if the pages that you have are the same as mine, but I think it's page 73, where you have a copy of the title plan. Now, this is an interesting situation because this is a premises which is owned by the licence holder. There's no lease in place. And so what we have to refer to is the land registry plan. And I know it's not abundantly clear. One needs a magnifying glass to look at it, but you can see outside of the door of the premises, there is a small area which is part of the premises that's registered with land registry.
Do we have a picture of that, anybody?
Well, there is indeed a photograph which might actually be of some help. Let me just take you to what I have as page 36.
Okay.
It's a picture, it's a photograph outside the premises. And you'll see from that that there are balloons around the entrance, and there is a barrier that's been erected. Yes, you can just about see it on that photograph, at the front of the photograph, which runs along the boundary of the premises. So that area, it's a very small area indeed. That is the area that is intended for outdoor consumption. And as I say, because there is no need for a tables and chairs licence, that brings with it a slight complication to the proposed condition. What we have suggested, I'm grateful for Noise and Nuisance negotiating on this and discussing this. What we've suggested is that we are after the same thing. We are not wanting people to consume alcohol on the pavement. But we do want people to consume alcohol within the extent of the premises as defined by the land registry plan. And the point really comes to how do we tie that down in a condition? Well, our point is that we can certainly, as the licence holder, prevent people, or we can sell to people in sealed containers. But what we can't do, and what nobody can do, is prevent customers on the pavement from opening bottles and what have you. And so putting a condition on the licence which effectively requires compliance by the customers that they will not take away open containers is unachievable. So that's why we've proposed the condition that we have, that no alcohol be sold for consumption outside of the building except in sealed containers. That's the obligation that could be put upon the licence holder. Or to customers, or for customers seated at tables in the designated tables and chairs area outside. And you have a plan which shows that area, which essentially equates to the area behind the barrier. So I think we are all in agreement in terms of noise nuisance and ourselves about what we're trying to prevent, i.e. customers consuming alcohol on the public pavement. It's just a question of the wording of that condition and how we can make that enforceable against the licence holder and capable of compliance. I hope that's clarified matters. It doesn't help with the plan that's attached to the licence, of course, which doesn't show any external areas, and likewise, it doesn't actually show the extent of the premises in that respect. All it shows is the area that's authorised for the sale of alcohol.
Okay. I'm wondering if it makes more sense for us to hear and from an environmental health's case so that we can look at this in the round. Does the committee agree? Do you agree?
Yeah.
Yep. Is that okay procedurally?
Yes, you can change the procedure as long as everybody gets a chance to ask questions. It's not a problem.
Yeah, I think it makes more sense.
Chair, I'm very happy for that approach. Of course, the guidance is that these hearings should take the form of a discussion led by the chair, and I think that's an eminently sensible way forward, especially when we are so close on what is just a very small, perhaps niche academic point.
Okay, well, let's hear what environmental health has to say.
Hi, Chair. I won't go over what Mr. McElroy's already put in the papers because I know you've read it, and as the applicants have said, we are very close to an agreement. I don't know whether it helps you, but I have got the land registry plan on my computer that actually shows this bit of land that they're referring to as being their land. I don't know whether you need to see that or not, but I have got it here if you want. I know it literally. I only got it like 5 minutes before we came down, so I haven't sent it to anyone.
I think that helps.
But as I mean,
Can I just, I know you're in the middle of your speech, but can I just quickly interject here? Public law rights can coexist along private law rights. So the fact that that area falls within your legal title is neither here nor there for whether or not it's classified as highway. I don't know what whether you've had any dealings with the Highways Department, whether there's any dispute over this area. I've got no idea. But just because it falls within your private title doesn't mean it cannot be highway. It can either, it's probably not publicly maintained highway, it could be. It could well be privately maintained highway. So I just want to make it clear from the outset, just because it falls within your red line of ownership does not mean it's not highway. But obviously that is for the Highways Department to decide. So I just wanted to just preface everybody's discussions with that.
Okay, do you see value in Mr. Richardson putting up the papers? Are you okay with that?
Yeah.
Yeah.
shall I email this to you? Yeah. Right.
Can you hear him? Yes. Okay. No, he has to email.
We're just going to put this picture on the screen.
So we can look at the land registry.
Because of how big it is, I'll make it horizontal.
Sorry?
I'll make it horizontal because of how... Sorry?
He can use the pointer, can't he?
I guess so, yeah.
Is it possible to have a physical copy, because it's quite hard to see on the screen? I just don't
Okay, can you,
don't want it all to-
can we operate with a pointer? Do you have a pointer on the small screen?
You-
Okay, I'll circle it for you.
I think the point...
Can you zoom it in a little bit more? There, so you can see the area of land where the number 1 is, just that little oblong of land there is the land that the applicant's referring to as being their land. So if you look at page 36 in the booklet, the picture we had before with the barrier and the balloons.
Do you have a pointer?
No, sorry.
Do we?
Just that little, see where the number 1 is? It's that little oblong within
No, not that bit.
that little bit at the front.
Yeah, okay.
It's the sort of the tiny oblong to the left of the O of Holland and to the... So that's the pavement line. So, no, where they've just drawn. So further down, further down, further down. So that little oblong there, that is the area of land that the applicants are referring to as theirs, which is the bit to the right of the barrier and the balloons on the image we saw before,
Okay.
which is what they're proposing as using as the outside seating area. So I think that's, if I'm not wrong, that is the area of land you're referring to. Yeah.
Okay, so where is the RBKC position and his position, where does it collide?
If I jump in here, Chair, I think, please correct me if I'm wrong, our position is that because that little oblong bit isn't included on the premises plan, they don't have the ability to drink outside. That's our position. Whereas your position is that it does form part of the premises and they can consume alcohol there in any event. Is that correct?
Yes, indeed.
Okay, so that's where the difference of position
Indeed.
is.
But I'm grateful for the time we've actually taken to put this on the screen, because I took the opportunity of speaking to my friend across on my left, and I think we have an agreed position on a proposed condition. That proposed condition just means a slight amendment to the licence plan to physically show an external drinking area, which that can be provided. And then on the proposed conditions that have been forwarded by your legal advisor, on 30, there's a condition which suggested that the sale of alcohol for consumption off the premises shall be restricted to, and our agreed position, I think, and my colleague will respond to this, is that that should immediately be followed by customers seated in any external areas as identified on the approved plan or authorised by necessary pavement licence, and then B as exists. So that's an agreed position that we've just managed to achieve. As I say, it just requires the external area to be shown on an approved plan, and that can be provided straight away.
I think, sorry, we're kind of like jumping the gun here about.
Yes.
I think we both, Philip, have you finished your bit? Is there any more to add to your bit? Then we need to have questions, and then we need to come to the conditions. So otherwise, Yeah, because the councils need to understand it. And as I said before, there is that separate issue about public and private law rights, and we need to ask you questions on that.
Yeah, I would say because of that conversation we had whilst we were waiting for the plan, I think we would say we pretty much are in agreement. We've not got much else to say other than if you, on the application pack, page 35, whereas N36 there's the two images of the people who are drinking outside. I think the applicants agreed that the intention is for the people who are there on image 30 on page 35 to not be there by providing this area in the picture of page 36, which is what I think we all want as the same end goal, to prevent the complaints and to have people sat there rather than standing, because standing you can get a number of people in there. It's not a huge space. Seated, it's going to be a limited number. I don't know whether we could get those pictures back on the screen. Yeah, so the other way. So yeah, so 35, that's page 35. All of those people outside there, that is people on the public highway, which is what's caused the complaints and what we don't want. Whereas on page 36, next one down, to the right of that barrier is the area of land which is under their ownership, which is where we're agreed people to be. And as we just said, that condition, the wording of it, pending it all being legal and enforceable, would be agreed. So I don't think I've got much else.
We're going to start with our solicitors going to ask questions.
Yeah.
Then the committee will.
So I just want to say, have there been discussions with the Highways Department about the status of this bit? I know you're saying it falls within your private ownership. Totally get that. Totally accept that. Have the Highways Department had any involvement? Do you know? I suppose what I'm trying to say is the way the condition is worded at 30 is it's an either-or condition. It's saying it requires a pavement licence only if it's necessary. So have you had any involvement with the Highway Department over this area of land at all to date? Do you know what their view is?
No, we've had no view from the Highways Department at all.
Have you had any discussions with the Highways Department?
No, we
So
haven't
no
approached.
discussions.
We haven't approached them.
And no
So
view.
we've taken the view that that's private land and therefore not subject to the requirement for a pavement licence. That's the approach we've taken to date.
Okay.
But no contact.
Yes, of course.
I know this is quite complex, and I have looked into this before for other reasons, but my understanding is that you can have a privately maintained highway, and obviously there's a publicly maintained highway. If that land that you say is yours according to the land registry is privately maintained highway, then I think there are restrictions on how you can use it and what you can use it for. So I'm going to defer now to Lindsay to see if that's correct, but that's my understanding of the situation.
So a pavement licence is required for publicly and privately maintainable highway. So if that small section of land which falls within your ownership is regarded as being highway, then you're going to need a pavement licence, which is why I've just kind of hinged the wording of the condition to say any necessary pavement licence, because you may not need one. If highways say you don't need one, all well and good. But if you do need one, then obviously you're going to need a pavement licence. It's just standard wording we put in, because obviously just because it falls within your ownership doesn't mean it's not highway.
Do you have a view on that licensing?
Not so much regarding the pavement licence. It's not something that I'm very familiar with. But certainly what we would need to know is where the designated area is. And so if the committee is minded to grant this application and put conditions on, we would need to know today exactly what that designated area is.
Okay.
So yeah, it would have to be identified on the plan.
I have another question. Maybe the lawyers can answer this. We see a picture here of outside the bar with the barricade, and the question is that, does that require a pavement license, correct? But what about these people standing outside the barricade? Whose jurisdiction are they?
Is that the photos you took on the 30th of August, Mr Richardson? Is that what Councillor Evans is referring to? Which I think you've
Page
responded
36 and 35.
Yes, so as far as I'm aware, that on page 35, those are customers of the Stumble Inn on the public highway, so the responsibility for them would be the Stumble Inn to manage their customers, their patrons.
Sorry, just to clarify, sorry, Mr Payne, you're saying that there won't be any customers on the pavement pay. So I'm going to refer to it as the recessed area and the pavement, just to distinguish the two areas. You're saying that your off sales are not going to, you're not going to have people standing on the pavement area. Is that correct?
Correct.
Okay.
That is something that is in common. We both want to prevent from happening.
And you said that those pictures relate to a one-off event occurrence on the 30th of August.
A private party that took place, and action has been taken against the staff members that were on duty that night about allowing that to happen. That's not something that we would expect to happen and shouldn't happen.
Okay, so if the committee were minded to grant you off sales today, and if the committee were minded to favour Ms Dyble's view versus your view, and include the recessed area as off sales, obviously you consider it to be on sales, but how much would just be where the tables and chairs would be, just in that recessed area?
Yes, correct.
How many?
In that recessed area behind that barrier.
And do you envisage how many tables and chairs, just out of interest?
Well, there's a possibility there'll be no tables and chairs, but well, no tables. I think probably in that area that there would be space for no more than 2 tables, I would think. 3 tables at the absolute most, and probably 4 to 6 chairs, something like that.
How many chairs, sorry? 4 chairs?
4 to 6 chairs, I would imagine. It's not a very big space at all.
And just to be clear, obviously Ms Dyble's made her view clear. You regard that area, which is in your ownership, you regard that as forming part of the on-sales, whereas we regard it as should fall within off-sales. Is that correct? Okay.
Yes, we regard that as part of the premises.
Okay. Okay, do you want to start asking some questions, other questions?
I've got a couple of questions, if I may. I know that area quite well, and I have actually seen other people outside the premises, and not just, I don't know the date of this particular occasion, but I have seen people outside the front. So could you possibly tell me what the procedure is when, as people can drink inside, but that's actually out the frontage. Can you tell me what the procedure is of management to try and control that and try and perhaps get people to come in or get them to go? But on a couple of occasions, I've actually seen them with alcohol.
Yes.
So it's not just this picture. I think that it's right. Happened on a couple of other occasions.
Right, it should not happen. The instructions to staff who are on duty are to intervene with customers who are on the public highway to either move into the area which is part of the title plan, if I can call it that, or inside the building, that they're asked to intervene with that. Customers are not expected to be on that public highway, is all I can say. I think there's a regular briefing on that.
Is it possible to have clarification of how? I mean, for example, how many staff are there on duty inside?
We have 3 staffs.
Sorry?
We have 3 staff.
So there are 3 staff on duty.
3?
Yes.
All right, so it's a busy place, so who is actually responsible? And just to walk me through, actually, do people check outside? How often do they check outside? What's the procedure? How do they ask people to to come in?
Stumbling is a very small space, so from the inside we can see if anybody goes outside to the payment side, we always go and tell them you are not allowed to stay on the payment side. If you want to have a cigarette, you had to come in to the other side to our premises and have a cigarette. And we always ask them to move it from the payment.
I'm sorry, I didn't completely understand. Could you...
So if the customers goes to that highway side, payment side, we ask them to move it from there, come inside, or if they want to have a cigarette or anything, we ask them to go to our outside small space there, as in the barrier, to have a cigarette or something, and we always ask them to move it from the payment.
So, how often does a member of staff go out and check the frontage?
Oh, it's a very small space. We are always, somebody is in the front of the shop. From inside, if you see that, always we can see them outside. It's the window is, the big glass door is there, and we can see them if anybody is going that side. So we keep an eye all the time.
All right, so you keep an eye on the frontage when people are inside, but isn't, given the fact that you do have people who want to go outside, it might be a warm evening, is there no procedure for a member of staff
Yes.
to go, how often would they go out and check the frontage?
Because we don't need to go outside, because when you're standing inside, we will know somebody is going to which they are not supposed to go. So straight away we go and tell them, you are not allowed to be this side.
And presumably, if they're outside, are they got alcohol in glasses, or should they, if they're going outside, are they in plastic? How do you serve it?
Oh, we don't serve it now outside. We don't. Nobody takes drinks outside now.
To answer the question, I think there's a condition on polycarbonate use in any case.
Which condition is that?
I think there's a... Let me just check, but I'm sure there's a condition on polycarbonate.
I'm not sure I've seen that, but correct me if I'm wrong. I think the only condition is existing condition 15, which says... Ms. Stiebel, can you just clarify something? I'm a little bit confused. In the pack, condition 15 says signage shall be prominently displayed advising customers that drinks or glass containers are not permitted outside the building. But the application says that existing condition 15 is signage shall be prominently displayed advising customers that drinks in glass containers are not permitted outside the building.
Yes.
Is that a typo? Or what's
the licence was amended to have the word in.
When was that done, Ms. Stiebel, please?
Yeah, so, we did receive a request from the applicant's solicitors, I think it was in April this year, stating that the condition had been misworded in the application and subsequently the licence, and that the word or should have stated in. Now, we did go ahead and amend the licence because we accepted that it was a typo, but having reflected on it, actually it changes the nature of the condition completely. From what was in the original application and what was consulted on with the Environmental Health Department. Certainly, I'm aware, looking back at correspondence before this hearing, that at the time the original licence was granted, it was clear to the noise and nuisance that that condition meant that drinks would not be taken outside. by changing it, it does change it so that it only refers to drinks in glass containers rather than drinks or glass containers.
So it makes it less restrictive.
It does make it less restrictive.
But you are where you are. You've amended the licence, so we can't go back on that. Yeah.
No, we
Okay.
amended it, but yeah, that's the position.
Okay.
Chair,
Okay,
just
so
going,
sorry.
just going back to Councillor Wade's question there. There is already on the licence condition 12, which relates to an external management plan, which I don't think Noise and Nuisance have actually seen yet. So that could be amended to include the proposed outside areas and how they would be managed and how they would prevent people going to the pavement side rather than the recessed side. I think that would be a fairly easy amendment for them to make, to
Are you
manage
able
that.
to check at all? Mr. Darby, are you able to check if a DEMP's been submitted?
I'm aware that the plan was sent to the licensing team. I've not received any confirmation from the applicant that it was also circulated to the police or Noise and Nuisance, and certainly, as far as I'm aware, Mr. McElroy has not seen that plan, that
Perhaps the applicant
external
can confirm.
management plan.
Mr. Payne, do you know the answer
Yes,
to
I'm
that?
just trying to look at that. My
Thank you.
computer's frozen rather
No, no, take your
unhelpfully.
time, take your time.
But my understanding is that it was circulated immediately after the licence was issued. Indeed, I can recall, because I had some input into helping draft that plan, using my past experience as an environmental health officer. But let me just see if I can find a copy of the email that forwarded it.
Okay. And just another question, sorry, if you can multitask at the same time. So if condition 15 was amended and it effectively was made it less restrictive, so do you agree, as it currently stands, any drinks, so long as they're not in glass containers, can be taken outside at the moment, even though you say that you don't allow drinking outside?
Yes, that's the
Thank you.
condition that's there. That's what I was getting at, I think, in terms of,
Is it
to
possible?
look at it the other way, a polycarbonate condition.
Yeah. it doesn't have a-
Just to get back to some practicalities, because I think there's kind of a slight... So what is the capacity inside your, inside the inn?
It's about 30 people.
About 30 people. And the presentation, because I haven't been inside, the presentation of the bar and what is actually if you've got 3 people on per shift, and if I went into the public house, would it be in front of me or would it be to one side? Your bar?
So the bar is, it's a very small area. So bar is in the middle and the seating area is in the front.
So if I come in,
Yeah.
do I see the bar?
Yeah.
I don't see it here, I don't see it here, I see it in front of me. So it's at the back of the business, the back of the site.
Where that dot is.
Yeah, this is the bar. It's the bar. This is the seating area.
So the bar's here.
So always one waiter will be one person serving the customers here.
Chair, I wonder if you could turn to the plan that is on what I've got as page 21. That's the outline of the building.
But,
This is 20.
yeah, but the problem is I can't see where the bar is on it.
No, indeed. Well, I'm just about to describe. The bar runs, you can see where the little dot is in the centre of the building there.
Yeah.
The bar runs from there up the plan. That's in that direction. I think not to the full extent, but it runs from that point there. The area, that's it, just like that. The area below is the seating area where there's a member of staff who does waiting on. That's exactly it there. Oh, 2 staff waiting on, yeah. So one behind the bar and then 2 staff waiting on in that lower area behind what is at the very bottom a plate glass window.
I'm just querying the visibility line. I've worked in a pub, all right? So you're behind the bar, you're serving people. How can people behind the bar actually see what's physically in front of the building and on the
Yes.
what looks like a flank window?
I just mentioned that there are 2 members of staff in that lower area up against the plate glass window, between the plate glass window, which you can see at the bottom of the plan, and where the bar starts. So there are 2 members of staff circulating throughout that area, serving and attending to customers at tables. So they have a clear visibility out through what is a plate glass window. You can see it's drawn on the plan as not a wall but a plate glass window at the very bottom. So that whole end of the building, yeah, is at the very bottom of the plan, yeah, there, and the very bottom of the window there. That's a window. The whole of that wall is effectively a window that you can just look through.
And
so
that's
that,
a payment.
yeah, and the other side of that window is where the photograph shows a number of customers having stood on the pavement. So it is effectively less of an obstruction, I would suggest, than it is from you to me in terms of being able to see what's going on outside.
Mr. Kumar, is this your first bar? Yes?
Yes.
Okay. And did you take a bar course? Who's licensed in there?
Yes, I'm a license holder.
Okay. And are the other 2 licensed as well? or-
Yes.
Okay. And just wanted to check something. Have you spoken to any of your residents, associations or anything? Have they spoken to you? Have you engaged with them at all?
We have only one resident. He lives in the first floor. It's our tenant, and I have spoken to him. And we said if all this time we didn't have any disturbance apart from the one private party. It doesn't happen all the time. We didn't, as 6 months, that's only one private party we had it. And other than that, we are not busy, or at the time, maybe about 10 customers. That's a maximum. Maybe 15 is the most maximum we have. And not all the time also. We are a very small neighborhood bar.
And what do you serve there? What drinks do you serve?
We serve beer, cocktail. Mainly we are a cocktail bar. High-end cocktail bar.
Okay. Is there any food at all?
Yes, we have food also.
Can you be more specific, please?
We have from small plate to large plate food.
Nuts?
Yes.
Yes, okay. Okay, committee, any further? No? So,
See if they've got any questions of each other, then we'll go to...
yes. Do you, anyone else, do you have questions of each other?
Chair, in view of what we've agreed, no, there are no questions, thank you.
Okay, then I think we'll go into, we will go into the conditions session with our lawyer. It's a little more informal today because there's so few people here. I thought, let's have some latitude to have a discussion.
Thank you, Chair. Right, obviously everybody's had a chance to have sight of these conditions. So you're seeking to add off sales to the licence, And you also want a non-standard timing on New Year's Eve to New Year's Day till 2 in the morning. You've said that the off-sales, so obviously there's a disagreement over the recessed area. We say that off-sale should apply there. You say that on-sales already apply there. But you say that there aren't going to be off-sales to people standing on the pavement. It's going to be for people taking alcohol away. Is there any latitude on the timings? Do you think people are going to be wanting to take away alcohol at midnight? I'm just throwing it out there as a question.
So, yes, there is latitude.
Thank you.
We would be content to restrict off sales to no later than 10 p.m.
Thank you. Right, moving on to the conditions. Obviously, existing conditions 15 is as per amended in April. So you want to change that from signage shall be prominently displayed advising customers that drinks in glass containers shall not be permitted outside the premises building to drinks in open glass containers are not permitted outside the premises building. Can you just explain the reason behind that, please?
The reason behind the variation is to allow that provision of off sales to customers, because there have been requests for drinks to be purchased at the premises to take home and to consume elsewhere. I think it's helpful also to clarify the provisions in relation to that outside area.
Thank you. Right, so moving on to the 3 conditions suggested by Environmental Health. Can I have your comments on 28? I think you've agreed that one previously.
Yes, that's agreed.
Number 29, I think you've clarified that the tables or chairs are going to be placed in that recessed area, and you're happy for them to be removed.
So 29 is essentially remove all the tables and chairs by 2200 every day, unless a tables and chairs pavement licence says otherwise. Yes, we're happy with that.
Right, so sorry, just to be clear, are you happy with my
as
wording
worded?
In red
Yes, as
below?
worded, yes.
So obviously subject to the terms
Yep.
of any necessary pavement licence, authorising the placement of tables and chairs, they're to be rendered unusable or removed by 10/8. Okay, you're happy with that?
That's fine.
Thank you. And then going on to number 30, I didn't quite catch all your wording, perhaps you can repeat it now. Can you just comment on my wording in red at the bottom, please?
So what we would like to try and achieve with this is to make sure that there is a clear separation between the Licensing Act provisions and the provisions in relation to pavement licences. They are 2 separate and distinct regimes.
Yep.
What we are trying to achieve here, as far as this licence is concerned, is that alcohol may be served to customers behind the barrier on the private highway, if we call it that, behind the barrier to those customers, and not to anyone else. If anybody else wishes to purchase alcohol to take away from the premises, that should be in sealed containers.
Does my condition not do that, though?
So the issue with the condition is the slight overlap with pavement licences, which is why the suggestion that I've just discussed with noise and nuisance is as I've set out. And let me just read that again. That the sale of alcohol for consumption off the premises shall be restricted to, and this adds something in as well, customers who are seated in any external seating areas as identified on the approved plan.
Can you slow down? I'm
Yes,
sorry.
I'm
Customers
sorry.
who are seated in...
Yes.
Sorry, can you repeat that?
So before your A,
Yep,
add in customers seated in.
yep. And then A.
Customers seated in any external seating areas. And then after that, as identified on the approved plan.
Is this part of A? Sorry.
Yes, part of A. So after areas,
Yep,
insert the words as identified
yep,
on the approved plan.
yep.
Or-
Approved plan being a tables and chairs plan, not a premises
No,
plan.
the premises plan.
But you can't amend the premises plan now because you haven't done that as part of your variation.
Yes. And my intention, I am mystified because I thought that a revised plan had been sent to licensing. I can easily provide a revised plan immediately to show this external area. So we can deal with that particular plan.
Can I just bring in Ms Dyball here? I mean, I'm not aware of any revised plan. I don't know if she is or anyone else is. And can I just ask for your view on amending a premises plan? That hasn't formed part of this variation application as far as I'm aware.
If the only amendment is to designate where this
Tables and chairs.
outside area is, where tables and chairs will be, then we would have no issue with that.
But you're
Yes.
not
Because
okay
if-
with widening the existing premises plan to include the outside area?
The it can be identified on the existing plan, but if the condition is referring to a designated area, then we need to know what that it needs to be shown on the plan, so there's no confusion about where that area is, where those tables and chairs should be.
I think I don't know if I'm talking at cross purposes. Mr Payne, are you suggesting that you want to, obviously there's a dispute over the extent of the premises. We say for on sales it's just inside, you say it includes the recessed area. Are you suggesting, other than the tables, designating a plan for tables and chairs, are you suggesting amending the actual premises plan itself to include that area?
Yes. Effectively, the amendment is an amendment to show the area to which this condition applies. That's perfectly legitimate course of action to show that on the plan.
Was
that
that
included as part of the application, though, Sharon? And should it
Well,
be included?
I mean, if the plan is amended so that it shows where the designated outside area is in relation to that condition, that's
okay,
fine. It
yes.
doesn't extend the
On-sales
licensed
area.
premises as such. It's just to clarify where that condition is,
Yeah.
what that area.
Yeah, so you're okay having an area showing where the tables and chairs are, but you're not okay with saying the
To
on-sales
extend-
plan is being extended
No.
to, yeah, okay, that's
No.
what I just wanted to get
No,
clarity
that's
on.
right.
Yeah.
It's purely just
Yeah.
to show where that designated area
Yeah.
is that is referred to in the condition.
So on the license plan, this is the license plan and that's the off-sales area.
Yeah.
And if they wanted to make that part of the license plan, they'd have to do
Yeah, it's not a red line within the
Okay,
red line.
thank you. Okay, again, we're obviously, there's obviously like a difference of opinion. You think the premises plan can be changed, you think not.
Sorry, Mr. Payne has actually just handed me a copy of the plan, and he's just marked on there the external area, which we would be satisfied with. It doesn't fall within the licensable area, but it does show where that designated external area is.
Just for the purposes of
Just for
tables
the
and chairs.
purposes
Yeah,
of
that's
the
fine.
condition.
Yeah,
Yeah.
that's fine. Thank you. Okay, so, sorry, Mr Payne. Right, going back to condition 30. So it's I'll probably have to listen to the recording because my writing's all over the place. My wording as it is, the sale of alcohol for consumption off the premises is to be restricted to the external seating area, which will be that plan, where obviously authorised by a necessary pavement licence if it's needed, and customers taking away sealed bottles of alcohol away from the premises. Is that your understanding too?
That's
So So you're saying the external seating area is going to be as depicted on that plan,
Yes. And
which
that,
is going to be in the recess area.
and then that eliminates the point about the reference to the pavement licence.
Well, we
Because
don't know that for sure, because we don't know for sure whether it's
No,
highway or
no,
not.
indeed. But my point is that if a pavement licence is required, a pavement licence is required.
Yep.
And that's not relevant to the consideration in terms of the Licensing Act 2003 licence. So my point is that you have a clearly defined area on the plan for the purposes of this legislation, and then if a pavement licence is required, the whole point about duplicating regimes springs to mind at this stage, then that is something that could be picked up and, if necessary, applied for under the pavement licensing regime. So we don't need to mention it in condition 30A because it's already taken care of by virtue of the plan. And then B can remain as it is.
Okay, I think the committee will take a view on that. I mean, I accept separate regimes like planning and pavement licensing as separate. I totally take
Yes,
your
indeed.
point there. I do get that. But obviously, we're not saying you do need a pavement licence. We're just saying if you need a pavement licence. But
Yes.
I think the committee will take a view on that point ultimately.
What I don't want to end up with is a situation where, on one hand, you're saying, yes, you can do this for the purpose of the Licensing Act, but then it can only actually take force once a pavement licence comes into place, because that is then overlapping regimes.
But then if a pavement licence is required, just for argument's
Yes,
sake,
and
then you're not going to be able to have tables and chairs there anyway. So it's
Yes.
more of a belts and braces approach, because
Yes.
obviously it's an external area, and obviously the noise and, I presume, the noise and nuisance concerns were to do with the external area, weren't they, not the internal area? So
Yes. Yes.
I think it will just focus the minds and be belts and braces by, personally, I think, including the wording, but it's not my decision to make, it's for the committee
No.
to decide.
No.
Thank you. Number 31, are you happy with that? Let him just
I think that apart from the cleaning of the area, I think he's got to provide receptacles for cigarettes, because that's kind of, if people are going out there to smoke,
Yes.
that actually they need somewhere to put their butts.
Absolutely. Absolutely.
But but it's also washing and cleaning the area so it's pleasant for people, including your customers.
to maintain that area, absolutely. So in terms of 31, if I can deal with that first, save for 6 smokers, we would suggest, and there's no issue with things like ashtrays and indeed making sure that the area is maintained in
And
a
would the
clean...
6 smokers be in your recessed area or beyond the recessed area? I know smoking is not a licensable activity. But I just
This is
wanted-
the external area that we're talking about, 6 in that external area.
So external area being the recessed area?
Yes,
or,
yes,
Okay.
exactly so.
All right, so okay. You want 6, okay. Does Nice Nuisance have any view on that?
No, I think six is okay, especially if those tables and chairs aren't there after 10 p.m. Then you've got the space for 6, so it should be okay. Can we pop back to condition 30 at some point as well?
Yeah,
Can you just repeat the wording you've got for the very first bit, the sale of alcohol for consumption, that bit?
Well, it's just as the word, my wording as per on there.
Yeah, so off the premise shall be restricted to customers sat at that bit. Have you got that bit in
The
there?
sale of alcohol for consumption. Well, I think Mr. Payne was suggesting some additional wording, but
Yeah.
I think I was saying that my wording was probably sufficient. Unless
Because
you've
we
got any
wanted
comments.
we wanted the bit of the customers being sat at tables, so there would be nobody vertical drinking outside, so it would only be for customers sat at the tables, is what we were after.
Wasn't it condition 29, which was subject to the terms of any necessary pavement licence authorising the placement of tables and chairs on the
Yeah.
highway? All tables and chairs are to be rendered unusable and removed by 10 p.m. each day.
Yeah, but then for condition 30,
Yep.
what Matt and what we're looking at is for those customers who are outside drinking to be sat at the table, so there'd be no vertical drinking outside, so you can only drink outside if you're sat. so there'd be nobody standing in that area drinking. I think that's what we agreed.
Is that correct, Mr. Payne? So no one standing in that recessed area, all seated?
Other than smokers?
Yes, that was the purpose of my insertion of those words.
So all seated. So it's up basically until 10 o'clock because tables and chairs have got to come in by then.
Yes, so my wording was that sale of alcohol for consumption off the premises shall be restricted to A, customers seated in the external seating areas.
Okay. Okay. Any other questions? Any other questions? Sorry? Yes, yeah.
Lindsay, sorry, can I just raise a query just about 31? Smokers are to be in the external area. What about the area
Beyond
on the pavement? Because this condition obviously only relates to
the recess.
the external area, the recessed area.
Are you happy to have wording just restricting smokers to your little recessed area?
I'm conscious about the powers that exist over people on the public highway, and to that point, I think that having wording along the lines that staff will, one can't insist that they move, and I'm conscious that perhaps the word encourage is perhaps slightly too weak. Perhaps wording along the lines of attempt to persuade customers on the public highway to move into the area would be, or use reasonable measures is something that I've used in the past on applications. So staff members shall use or employ reasonable measures to persuade customers on the public highway who are smoking to either re-enter the premises or to move into the external area of the premises.
Ms. Dybel, do you have any comments on that, just based on your experience of other conditions that we normally apply?
I mean, one of the concerns is obviously if he's got if there are 6 customers already in the external area, how many potentially other customers could be standing outside smoking? I mean, it is a condition that has gone on
other
licenses.
If it's in the direct vicinity, you should be able to control those, shouldn't you?
These are the applicant's customers.
Yeah.
And so, you know, if they're outside the premises and coming back in, then...
And you've got line sight anyway from the entrance, and probably have you got windows at the front as well, so you can see, I guess.
I mean, there could be something included within the management plan, but I think we would just... I think we don't want to fall foul because we've only designated that there should only be 6 in the external area, and then in the rest
20
of the,
outside in the
well,
other bit. Yeah.
That is the potential.
Yeah, and I've noticed there's a condition the capacity of the premises is actually 60. I know you mentioned probably 30 comfortably, but potentially, I mean, I'm not saying there'll be 60 smokers, but whilst I accept that smoking isn't a licensable activity, and whilst I accept that there's a limit to how far you can control people, I mean, if they're in the direct vicinity, like standing outside your premises, I don't think there's any reason why the 6 couldn't cover that area too. Can I just have your thoughts on that?
Well, the difficulty is what powers do the staff have over the public highway? And I'm conscious I've been here on many occasions on licensing matters, not in Kensington and Chelsea, but on licensing matters generally up and down the country. And the powers that they have are no more on the public highway than any other private individual. The power that they have is the refusal of service or the refusal of re-entry. That's the power that can be brought into force. But simply put, a member of staff cannot insist that a person smoking outside the premises on the public highway moves on. The person is perfectly entitled to stand there. Now, I think that the point has been made about the management plan, and that is indeed a sensible way about dealing with it, that it can be spelt out in the management plan, the technical detail and the practical detail about what measures will be undertaken, the words that are going to be used with the public that are on the highway. That's perhaps too technical to include within a condition, but I would suggest that there is a revision to the management plan to include those provisions for moving people who are on the public highway.
Okay. And just revisiting number 15 as well, obviously it's drinks in open containers. Does that cover alcoholic and non-alcoholic drinks?
Yes.
Okay. Sharon, do you have any more comments?
No, not on condition 15, thank you.
Thank you. Any other questions from the committee?
I'd like to go back to that point about people smoking on the public highway. Do you agree that your staff could say to them, A, if you cause if you haven't make noise, you cannot come back in, that's one. And number two, you could tell them to move along. This isn't the only place in the country or even in Kensington and Chelsea that has that issue.
No, I think I agreed to that before, that yes, we can prohibit them from coming back into the premises and tell them that they're not allowed back in the premises if they don't move along. Yes, we can tell them to move along. That's not an issue. What we can't do is insist that they do move along. But the indication I was giving was that in the management plan, we can put things such as, if there is a person seen to be smoking outside the premises, the staff member will approach them and say to them, in particular words, kindly move along, and then we'll escalate it to the point of, well, you're not coming back in, escalating it even further to the point, well, you're not coming back in ever again.
So I would ask Sharon, we have this problem with so many places, and we know that the answer always is, you don't own the highway, you can't tell me what to do. Normally, especially we have that late at night, so normally, what language do you think is suitable to get the point across? I think he might be too specific.
I mean, often the detail will come from a management plan, and if there is a situation that arises where there are a group of people outside smoking that would be in excess of the number, I guess the first thing that we would want to know is, okay, well, where's your management plan? What action did you take to try and deal with this situation? I appreciate that there is a limit to what the licensee can do when people are off of his actual premises, but nonetheless, we expect licensees to manage their customers that are outside their premises in a responsible manner. So, you know, I mean, the sort of pictures that were shown where there was the private party, clearly that wasn't being managed. There was a lot of people congregating there, and it is obviously their customers. They do need to manage it when they're going in and out to have a cigarette. So if they want to include it in the management plan, that's fine, but that detail would need to be provided to us, Noise and Nuisance, and the police for comment before you know, we accept that the management plan is sufficient to deal with those sorts of issues.
Okay, thank you. Solicitor, are you happy with that?
Yes, and I just want one final clarification for confirmation. You're happy for there to be, assuming that the application is granted, no off-sale consumption on the pavement?
On the public highway, we are happy to have that restriction.
Yeah, okay.
We don't want customers consuming alcohol on the pavement.
Okay, fine.
Obviously, we can't stop them, but that's not what we want at all.
Okay, thank you.
Okay. Do our licensing officers have anything to add? Nope. Governance? Thank you. We've reached the end of the meeting. We've heard all sides. We've had, I think, a fruitful discussion. We now have all the information needed, and we will retire to make our decision in private. We will not announce the decision today. Instead, the hearing will be closed. A summary determination will be sent to the parties within 5 working days of today's hearing. A full decision will follow as soon as possible thereafter. The time limit for appealing the decision will not commence until the full decision has been sent to the parties. Thank you for attending.
Thank you, Chair.
Thank you, Chair.